Welcome back to our review of the Supreme Court's term. I'm your host, Clark Kelso. Well, the court decided two interesting employment law decisions this term, and in both cases, the employee prevailed. We'll begin with the court's decision in Thompson v. North American Stainless, where an employee filed a claim for retaliatory discharge against the employer, based on the fact that he had been discharged after his fiancée filed a sex discrimination charge against the employer with the EEOC. The legal question before the court was essentially a standing inquiry, since the retaliation was intended to hurt the fiancée, yet the plaintiff was the direct target of termination. Title VII prohibits retaliatory firings with the following language, quote, "It shall be an unlawful employment practice for an employer to discriminate against any of his employees because he has made a charge under Title VII." Close quote. The statute goes on to permit a person claiming to be aggrieved to file a charge with the EEOC alleging that the employer committed an unlawful employment practice. And if the EEOC declines to sue the employer, it permits a civil action to be brought by the person claiming to be aggrieved by the alleged unlawful employment practice. The case came up on appeal when the trial court granted summary judgment to the employer, concluding that Title VII does not permit third-party retaliation claims. The Sixth Circuit affirmed, concluding that because the employee did not engage himself in any statutorily protected activity, either on his own behalf or on behalf of his fiancée, he was not included in the class of persons for whom Congress created a retaliation cause of action. The Supreme Court reversed. It gave the language in Title VII a broader interpretation than the Sixth Circuit did. First, the court held that the employer's action clearly constituted retaliation. As the court explained, "We think it obvious that a reasonable worker might be dissuaded from engaging in protected activity if she knew that her fiancé would be fired." Undoubtedly true. But this explanation then triggers the obvious question, well, if a fiancé is good enough, what about close friends? Where do you draw the line? Well, the court didn't give us much help here. It essentially drew some outer boundaries, but left a lot open for future cases. Here's what the court said, quote, "We must decline to identify a fixed class of relationships for which third-party reprisals are unlawful. We expect that firing a close family member will almost always meet the standard, and inflicting a milder reprisal on a mere acquaintance will almost never do so. But beyond that, we are reluctant to generalize," close quote. So that gives litigators plenty of room for advocacy. Having found that the employer's conduct violated Title VII, the next question was whether the plaintiff had standing to recover damages. The statutory language provided a right to sue to a person who was, quote, "aggrieved," close quote. The employer argued that the only person aggrieved was the plaintiff's fiancée, that is, the employee who engaged in the protective activity. The court rejected this interpretation as too narrow. The Sixth Circuit had suggested that aggrieved simply reiterated the requirement of Article III standing, and that anyone who had Article III standing could sue. Well, the court rejected this interpretation as too broad, noting, for example, that it would theoretically permit a shareholder to sue a company if a retaliatory firing damaged the company's share values. So the court found a middle ground. Drawing upon the zone of interest tests from the field of administrative law, the court held that the term aggrieved in Title VII enables suit by any plaintiff with an interest arguably sought to be protected by the statute, and therefore within the statute's zone of interests. Applying that test to the facts, the court held that the discharged employee could sue, because he was certainly not an accidental victim of the retaliation. He was, in fact, the intended means and mechanism by which the employer sought to inflict its retaliatory harm. As the court said, hurting him was the unlawful act by which the employer punished her. This decision is undoubtedly going to create some difficult problems for employers when trying to take disciplinary action against an employee who has a relationship with another employee who may have a retaliation claim against the employer. So the HR world just got a little bit more complicated. Our final case involved discrimination against military employees under the Uniformed Services Employment and Reemployment Rights Act of 1994, which forbids an employer to deny employment, reemployment, retention in employment, promotion, or any benefit of employment based on a person's membership in or obligation to perform service in a uniformed service. Liability is established under this statute if the person's membership is a motivating factor in the employer's action. In Staub versus Proctor Hospital, the court faced a common problem in employment discrimination cases where one employee significantly influenced but did not actually make an adverse employment decision affecting another employee. The question is whether that influence can be sufficient to make the employer legally responsible when the influence was based on a discriminatory animus. The plaintiff's two immediate supervisors were hostile to her military obligations. They took several minor disciplinary actions against the plaintiff and, in general, set her up for failure. Ultimately, they brought certain alleged transgressions to the attention of someone with authority to fire the plaintiff, and after conducting a brief independent review of the plaintiff's file, that person fired her. The company took the position that the firing was not the result of the supervisor's discriminatory animus, but was the result of an independent evaluation by someone who the plaintiff conceded did not have a discriminatory purpose. Drawing heavily upon traditional rules regarding intentional torts and agency law, the court held that if a supervisor performs an act motivated by anti-military animus that is intended by the supervisor to cause an adverse employment action, and if that act is a proximate cause of the ultimate employment action, then the employer is liable under the act. There is, I think, a lot of common sense and justice in this decision. An employer shouldn't be able to avoid liability for discriminatory employment practices simply because those practices are buried one or two levels below the final decision maker, especially when the decision maker is going to rely upon recommendations from those subordinates. Well, that's it for this installment of the Kelso Report Special Review of the United States Supreme Court's 2010 term. Thanks for joining us, and feel free to continue with the next set of programs, which will discuss the court's cases dealing with criminal law issues. I'm your host, Clark Kelso. Have a great day in the law.